wants to meet in what is called in committee. When the board wants to meet in committee, executives are often recused. So the principle of being asked to recuse is not an issue. It was the fact that it just came from the blue. It just came from the blue. I had no sense whatsoever that I knew the minister was coming, but I had no sense that she would arrive and ask us to excuse ourselves. And of course, in that instance, we truly complied with the.
And you were then later in that day issued the letter of suspension.
Correct.
With the view that you'd interfere with an inquiry or something that was going to take place. Was that the reasoning? And that inquiry, was that the Denton's inquiry? Are you aware? I'm just trying to pick up, is that the Denton's inquiry that was then instituted?
Yes, that was what eventually became the Denton's inquiry. I remember that there was the chair had in fact appointed another party to conduct the inquiry, but had not followed procurement procedure, so that fell through, and then Denton's were then appointed. And by the way, one of the things which was indicated was that we would be interviewed for that inquiry. I was actually never afforded the opportunity to speak to the investigators. Of course, as you may recall, when they first released one of the versions of that report, they issued a media statement indicating that there had not been any wrongdoing that had been found against me and the other executives. But I was not even favored with a copy of the report. I still have not seen the Denton's report.
Thank you. But they were appointed on the 20th of April to the 18th of June, which was in that period. And we now know the committee members have got a copy of that report, and it's quite a scathing and damning indication of Eskom at the time and the procurement, and it deals with a number of issues. And yes, it did indicate that there's no wrongdoing on your part, mainly because you were there for such a short period. But what it does indicate, for example, is significant breaches of the Public Finance Management Act in procurement, and that's what you raised as well in your earlier evidence, that there were significant issues relating to procurement. And if you take just one example, the diesel purchases, which seems to have been clothed with secrecy, where they indicate significant breaches of the Public Finance Management Act, as well as page 97, a potential wastage due to not arranging discounts with ad hoc suppliers, which may be in the order of 200 million rand over the past 2 years. Now that is significant, and it does raise a lot of questions. And it also mentions in its reports the diesel costs may have been a result of Eskom having to mitigate load shedding, but it does not make commercial sense to not seek to renegotiate the legacy contracts of diesel. And it is also concerning that 30 months can pass without a meaningful approach to drive down the cost of ad hoc diesel supplies. We know diesel was a big issue, and it says, taken together with the proliferation of red flags over the bona fides of the diesel procurement process, Eskom's management of this expenditure requires closer scrutiny. We now know that nothing was done with that report under the subsequent board, and it was, in fact, the next chairman, and it will be good for him to explain why he sat on that report, and when it did eventually come out, a lot of the issues came out. But I think I just wanted to put that part on record, and that it appears that that was the inquiry that was then instituted. What I'd like to just quickly with you in the limited time, I'd like to just raise the issue of your involvement and your knowledge of the Glencore Oakbay purchase of Optimum mines and the Tegeta issue. Because we know in July already of 2013, Glencore issued their hardship clause on the Optimum mine, and then price negotiations began. And they were still ongoing with your previous CEO, Mr Matona, and when you were appointed then in October of 2014, they seemed to have been progressing well. Now, the next CEO that is then appointed after you, Mr. Brian Molefe, immediately stops. What seemed to have been, and the evidence is that from the business rescue practitioner, that the negotiations with Eskom were ongoing and were progressing well with a renegotiated price. But then, when Mr. Molefe was appointed, he refused to sign a new agreement with Glencore, which forced Optimum into business rescue, and that was in May of 2015, which was shortly. You were there until March 2015. What was your role as CEO in overseeing that process of the Optimum negotiations on price, and were you satisfied with the progress that had been made?
Yes, I did deal with that matter, and at the time I dealt with it, already the negotiations had been underway between Glencore and Eskom. So, to a large extent, I was only just familiarizing myself with the issues at the time. It was a complex matter. So, I had given an audience to the Glencore executives who were responsible, and obviously they were lobbying. The Eskom negotiators, on the other hand, felt that they were willing to consider a different price. It was just a matter of where the threshold should be that would deliver a win-win. So I was quite eager for a solution to be found, because what Glencore was saying to us at the time was that, well, if they can't find joy, or an outcome, that is reasonable, they would have to shut down, and that would obviously affect, security of supply, to the plant. I think it was Hendrina, the station that they supplied. So it was in our interest that a solution be found, but a solution that was not at the expense of Eskom. So the Eskom negotiators felt that Glencore wanted Eskom to bear a disproportionate amount of the risk and the pain that was necessitated by the circumstances in which Glencore found themselves. I left the matter in that space. There was not no conclusion yet by the time I left.
Were you surprised when you subsequently heard of the steps that Mr. Molefe took as your successor to immediate cut off all negotiations with Optimum, with Glencore, impose a penalty, and put other pressure that we now have evidence of, which you might not have had? Were you quite surprised about that, and what do you think was the motivation for that?
I couldn't speculate about the motivation, certainly, and of course, what I do know is what I read in the newspapers. I do recognize, however, that it was a shift. It was a shift in terms of approach from where I left the matter, and what my successor actually eventually, the posture and the direction in which he managed the issue. Clearly, there was a significant shift. The reasoning for it, what information was before him that led him in that direction, I couldn't quite tell, and I couldn't prejudge.
Have you been following in the media the subsequent developments around the Tegeta and the purchase of Optimum, where we've heard of the evidence of the business rescue practitioner who indicated that had they been offered those same terms at the beginning as the business rescue practitioner, with a reduced penalty, 2 billion penalty down to 500, with being able to sell coal not to Hendrina but to Arnott, which was the export coal, at a significant increased price, that would have resolved the issue from the word go. And that was the negotiation and the resulting deal with Tegeta, which we know is Oakbay, which we know is Gupta related. Was that a surprise to you?
No, I followed all of those. I mean, I followed the story. I followed the story in the public protector's report, and I've been following all of those things. As I said, in relation to where I left the matter and what subsequently happened, clearly there's a significant shift, and on the face of it, and without actually delving into the details of this, I did not know what information was in front of my successor in adopting the position that he did. I couldn't, and it seems to me that that's a matter that requires a probing. I can hear what you're saying about, what the rescue practitioner said. It seems to tie in with where the matter was when I left it, because we were negotiating for a price, a win-win price for Eskom and for Glencore.
So you've read the Public Protector's report, and only a small part of that has been taken on review relating to the presidential powers. The factual findings have not been taken on review by Eskom or anyone else. And the Public Protector found that the board substantially benefited the Tegeta mines in this whole process, that the whole process was to benefit Tegeta mines. Would you have any reason to disagree with that finding?
No. I mean, it is what it is. It is in the until
it's taken on review.
Yes, until somebody comes with a different version of events.
Correct. And
this is what is out there.
Sorry to interrupt you. Our time is limited. But the more significant is you also found serious breaches of the Public Finance Management Act in this whole process as well. And you've already alluded to issues surrounding that as well. So I'm sure you'd agree that this is a matter that should be dealt with urgently, and one can't necessarily wait for a commission of inquiry. If there is findings of breaches of the Public Finance Management Act, then surely criminal investigations should be taking place at this stage, or at the time when that report a year ago was forwarded to both the Hawks and the NPA in terms of the Public Protectors Act. And a year later, we see no action in that regard. Is that a concern to you?
Look, obviously, any misdemeanor or allegations of the sort that we have seen deserve action. They deserve to be taken up. I'm still hopeful that we will get to that point, as it were. But you're right. I mean, I could not, as a practitioner of governance, accept that misdemeanor or allegations of that nature can simply just, be circulated in the way that they are, without any consequence. So hopefully there will be consequence.
One last small question, and that is the meeting that Minister Zwane participated in Switzerland. Now, your experience as a Director General, would you find that extraordinary for a minister to go and visit and negotiate coal mining contracts overseas? Would that be something that would be against the norm of a cabinet minister engaging in that practice?
I wouldn't necessarily say so, and this is not a comment on the merits and the facts as they pertain to that particular instance, because I think what really matters is what has gone down in that instance. But ministers interact with all kinds of stakeholders. So ministers, when they travel, they'll interact with business people, they'll interact with government, their counterparts. So the fact that a minister has met a particular company in and of itself is not an issue. The issue is what what was that meeting about? And I've always taken that issue to be really about what was that meeting about.
Sure. And if the prima facie evidence is that it is about finalizing the sale of Glencore's Optimum to Tegeta, then it could be a concern, obviously.
I noticed that it has been flagged as a concern. I don't think I'm in a position to charge without full access to the facts.
Thank you very much, Chair. Thank you.